Welcome back to Supreme Myths. I am very happy to welcome back to Supreme Myths someone who was here once before, Professor Jed Shugerman of Boston University Law School. He is he's a Joseph Lipset Scholar. He has a undergraduate degree, a law degree, and a doctoral degree from Yale. In a different podcast, we talk a lot about Yale, but we're not going to talk about that today. I'll have him back to do that. His book, the People's Courts in 2012, is a fantastic read about judicial review and elections. He's working on many, many other things as we speak. He has too many articles and essays to talk about, but what he basically is one of our leading experts on executive power in the United States today. And the last thing I'll say about him, and this is bad, and if we get to have time at the end, we'll get to this. Apparently, I've had him on my podcast now twice, even though Jed is a Celtics and Crimson Tide fan, two things neither of which that I can abide, especially the Celtics. But we will leave that for another day or to the end of this podcast. Jed, it's great to have you back. Thanks.
Thanks so much, Eric, for having me back. I think you're doing a great job with this podcast to explain complicated legal concepts to a broad audience. I'm really eager to help in that project.
Oh, thank you. I really appreciate that. And by the way, congratulations on the championship. Okay. Now, okay. By the way, this is the least hateful Celtics team of my 60 years of following the NBA. Anyway, so it's been a big term for presidential power, obviously, and everything we think about the executive branch. You are an expert in that area. Let's begin with this at a very high level, 35,000 feet. Jed, what do you think should be the role of originalism in separation of powers disputes? That's the normative question. The descriptive question is, what has been the role of originalism in the Roberts Court's resolution of separation of power disputes? Two questions.
Those are two big questions,
Yes.
and I might even have to break them into some sub questions.
Sure.
But the big picture point I'd make is, as just a matter of theory, as a matter of what would be the ideal in some world that we don't live in and that we will never live in, what is the best way of understanding law? And I describe this as as text. A lot of people describe this as you start with text and context. And you don't have text without context. You can't have legal context without a text. They have to go together. And what text and context are in constitutional interpretation is originalism. And I sometimes describe myself as an originalist in theory, or as a lexical originalist. And what I mean by that is an originalist in theory is this is what law should be in an ideal world of judges who actually cared about getting things right. And in an ideal world where judicial appointments were not driven by partisan politics and ideology.
Can I stop you? Jed, hold on one second. Judges getting it right. That's such an interesting statement. Right. And here's why. Richard Kay, who's an old-time originalist at the University of Connecticut.
Sure.
On your point about judges getting things right, Richard says, and I think he's the only originalist who really has made this a huge point, is that's not the judge's job. It is actually not the judge's job to get things right. It is the judge's job to rule in favor of one of the two parties based on the most persuasive argument available. Do you agree with him about that?
I do. Richard Kay has actually been wonderfully helpful in a project I'm working on presidential power and removal.
Great guy.
Because he has an encyclopedic knowledge of 17th and 18th century English history. So he sent me some. So Richard Kay is great. My recent former colleague, Gary Lawson, has the same idea, which, and I didn't, he is I'm very much on the left of the political spectrum, and Gary Lawson is about as far right on the political spectrum as any professor. And we all agree on this point, which is originalism is about what the law should mean in theory. And that's not what judges do. Judges are not legal theorists. Judges are not professors. Judges are adjudicating cases, and they need to decide cases within a judicial framework, which includes much more than just being historians. And we don't have a system that appoints any historians. I mean, the idea that Antonin Scalia said that the best historian he's ever known is Clarence Thomas tells you all you need to know about the difference between Scalia in theory and Scalia in practice. Okay,
Yeah.
so at this point, I mean, I've been saying this for a while, that this distinction. I think this term has made it inescapable, undeniable. That the judges who call themselves originalists are using the term cynically, that they're using it as cover for their ideological goals, and they're not even. And sometimes they pretend to be originalists, and make that the claim for their legitimacy. I think more than anything else, this presidential immunity decision, Trump versus United States, I think exposed the Roberts Court for being utterly unoriginalist, and driven by ideological commitments, not historical or legal commitments.
What's interesting about all that is I think I wrote 2 years ago, maybe it was last year, that there is no basis for saying the Roberts Court has ever been originalist, and that was long before this term began. I want to get back to something you said though, because I actually this is off the script, but I'm very interested in this. So you said you're an originalist in theory. I think you said that.
Yes, yes.
Can you just flesh that out a little bit?
Well, I think if we separate out the question from how should we interpret the Constitution in general, from how should we adjudicate it in disputes, exactly where you started with the Richard K. With this is judges are not trying to get it by. Another way to say, or another way to state the point that Richard K. was making was, it's not up to judges to get it right. What is it? It is not up to judges to get a grand theory of constitutional interpretation right. It's not up to judges to consistently interpret any clause that they could possibly imagine its application. They are supposed to adjudicate cases case by case. And that's a different proposition. And that's also, we can talk about this later, that's what departmentalism is. That's how departmentalism is different from grand constitutional theory. Departmentalism is do your job. I mean, to quote, I'm sure you're a fan of Bill Belichick too, I can imagine.
Yeah.
I'm not. I'm a Boston Celtics fan, not a Bill Belichick fan. But Bill Belichick's famous line is do your job. Well, a linebacker is not the same thing as a quarterback, right? So and not a head coach. The job of a judge is to adjudicate and balance. So
hold on. So we're all going to talk mostly about judges. In fact, the rest of this podcast is going to be about mostly judges. But
that's right.
Let's say you get a call from I know this is a impossibility, a well-meaning congressional committee. Okay, something we don't have, but a well-meaning congressional committee, bipartisan, that really wants your expertise on a constitutional question.
Yes.
Let's say it's, can we issue some kind of statute to weaken the court's immunity decision? I don't want to get into the nuts and bolts of that. When they call for your expertise,
that's right,
outside the judicial context, what sources of law / policy / interpretation are you going to use to give them your best answer to whatever the question is going to be?
That's right.
What sources are you going to use?
Well, I can give you an example that is happening right now.
Sure.
And something I think you and I have disagreed with, I think, online. Which and I just might, let's say hypothetically, I get an email from, I don't know, a Senate staffer, and this is purely hypothetical right now.
Yes.
Right? So let's say hypothetically Biden is now discussing judicial reform and how to limit the.
Well, that's not hypothetical, because he's told us he's doing that. So go ahead.
And it may or may not be hypothetical that I've actually gotten some of those emails.
Got it.
So let's just say I'm hypothetically preparing for this conversation with a Senate staffer. I can tell you what I'm going to say hypothetically. The issue of term limits. Can term limits be imposed on Article III judges or Supreme Court justices either way? And the line of the relevant line of the Constitution from Article III is that all Article III judges serve during good behavior. And it doesn't say anything explicitly about term limits. What I would say as a legal historian and as a constitutional interpreter is, was the original public meaning of tenure during good behavior clear? And I have a very high threshold, just to be clear about my theory of constitutional interpretation as a lexical originalist. If text and context are clear, then you stop there and you don't go to things like precedent or other jurisprudential categories. In the work that I've done over time, it is clear that both before the framers wrote Article 3 and while they wrote Article 3, they understood that tenure during good behavior was a legal concept. For Dune fans out there, this is the Bene Gesserit. The language in Latin is tenure during good behavior was Bene Gesserit or Bene Gesserit, and it meant tenure for life. Now, it didn't mean that until it meant different things at different times, but by the time you got to 1787, that's what it meant. And that, even though it doesn't say clearly as a matter of text that tenure during good behavior means to age 65, or tenure during good behavior can be tenure for good behavior during 18 years, it's clear that it meant life, and that thus a statute cannot impose a term limit on Supreme Court justices for 18 years or retirement at 75. That has to be done by constitutional amendment. That's what I say. Go ahead. Yeah.
So what you're saying is, if Congress passed such a law, judges should strike it down because we don't have to debate the meaning of good behavior. The vast majority of all historians look at it and go, no, that meant life tenure. They just didn't use the word life. They meant good, but they meant life tenure. But your standard is it has to be really clear.
Yes, but let me pause and say I recognize there's a gap between what a Senate staffer would ask me about what the interpretation of that line, tenure during good behavior, is, and what I think it means as a matter of text, context, history and tradition and precedent. Right. And what a judge should do. It is a little more complicated, that a judge has some self-interest involved, and a judge has to recognize that maybe, the legitimacy of the judicial department is at stake right now. And I don't think that overcomes what I am describing about text and context, but Eric, I'm acknowledging the point you're making, which is, as a law professor who's thinking about the meaning as a matter of what I think is true, is a different role from a judge who's exercising power. And the history of judicial review, the original public meaning of this kind of judicial power of judicial review, it had to have a very high standard of clarity, to the point that the statute was repugnant. And that's a difference. I'm trying to say, all things being equal, what's true. But a judge has to have some extra legitimacy to wield the extraordinary power of judicial review. And I think that's a harder question. I think in this case, it's clear enough, but I think one has to engage with the problem that a judge has so much power over life and death and real world disputes, and that wielding that power of judicial review better be based on so much more clarity than what I suggested in this conversation.
So we're going to move on to executive power specifically very shortly. But your whole answer to my question makes me have to say the following. Just last week, I was in Chicago debating Professor John McGinnis, one of our most noted originalists. And interestingly, for most of my part of the debate, I actually used his work because John wrote an article called The Duty of Clarity. And John is, as in theory anyway, John is as dogmatic an originalist as there is. He's a real originalist. And John's view is exactly what you just said, that the original meaning of judicial review was, or the idea of it, and this is not really debatable. I mean, there aren't dissenting voices. I've done the research. There aren't dissenting voices. The original meaning was judicial review would be used modestly, rarely, and only upon a showing of clear error, which McGinnis calls the duty of clarity. He and I disagree a little bit. I vote for super strong deference. He votes for just strong deference. But that difference doesn't matter because no court in American history since 1857 has employed any kind of deference that is in any way similar to the duty of clarity. And that's why originalism is inconsistent with itself. But that's a different podcast. Okay. For this podcast, you said that the Roberts Court has now proven beyond a shadow of a doubt that it is not an originalist court based on this term. And I'd like you to, I will shut up spend as much time as you want defending that proposition because I'm very interested in it.
Well, I will start with a decision that I agreed with in its result, but found a staggering, shocking but not surprising in the way it was decided, and by all 9 justices. Right? No, I mean and what I'm describing is Trump versus Anderson and the 14th Amendment case for the Section 3 of the 14th Amendment to disqualify Trump. Now, my view is it's a close case. But I think a lot of people just assumed that it was obvious that of course Trump had engaged in an insurrection, and then just applying the text of the Constitution, he was disqualified. So I thought it should have come out. I can go into a little bit of argument about why, but let me just start with what the court actually said, which was all 9 justices just completely made up this federal versus state distinction, that it's only a federal role, that who should have the power to disqualify. It's clear that the text of the 14th Amendment, Section 3, makes this standard a self-executing standard. And not just, what do we mean by self-executing? It doesn't mean the Constitution can't execute itself. What self-executing means is any actor in the federal or state government, because of the Supremacy Clause, has a duty to enforce the Constitution. And that means, as a state actor, they have a duty to take the 14th Amendment, whether it's about equal protection or due process, and they have a duty to comply with equal protection, due process, because it's in the 14th Amendment. So too is the Section 3. Those equal protection, due process are in Section 1. Section 3, in fact, is maybe even clearer that it is self-executing, because it has a provision to unexecute it, to undo a disqualification. It for the first time says Congress can undo it. Well, why would they need to say that Congress can undo it, but not say that Congress has to do it? It doesn't make sense.
Yeah, and Jed, that just for the non-lawyers in the room,
Yep.
Everybody knows the 14th Amendment says no state shall deny any person the equal protection, due process, or privileges or immunities. What Jed means by self-executing is we don't need a federal statute authorizing courts to enforce those provisions. Courts just enforce those provisions. We don't need a federal law. In the Section 3 case, the court said we need a federal law. Right.
And not only is that inconsistent with the rest of the 14th Amendment, nowhere else in the 14th Amendment is it necessary to have a law. Congress can add to it. That's what the 14th Amendment Section 5 says Congress can add, but that still, we all agree that equal protection in 14.1 and due process in 14.1 are automatically applicable from the day they're ratified to all federal and state officials. And if anyone had any doubt about
just state officials. No state shall. Just state officials.
No state shall. That's right. It is actually, there is a jump, but Eric, how important is that, right? It's of course this was an imposition on state officials to comply with this. If it was textually explicit that the 14th Amendment Section 1 applied to state officials, why would there be an implicit non-applicability? The whole thing, it's actually so obvious, it's kind of shocking that they had to bend over backwards with zero evidence that it only applied to, that federal officials could apply this to state elections.
Do you view that argument as a textual complaint, an historical complaint, or a combination of the two?
A combination. I think as a matter of text, all of this is signaled clearly enough. Yeah. And then this is also, as my lexical originalism suggests, it's clear as a matter of text and history, but it's also the way it's been consistently applied in the rest of it's just trying to make sense of how have we interpreted the 14th Amendment over more than a century. And so all of it lines up with the conclusion that state officials have a duty to apply this disqualification principle. Moreover, the idea that there's any difference between a federal election or a presidential election and a state election is utter nonsense. There's no such thing in America as a federal election. Right?
Wait, hold on, hold on.
Yeah, go ahead.
There's no such thing in America as a federal election.
There is
We
no such
need
thing in
you.
America as a federal election.
We, meaning you, need to explain that first before you
Yes.
move on. Explain that. Yeah.
Okay. So there are elections to state offices like governor or state legislature.
Sure.
Those are run by, and those are state functions run in state precincts with state officials. An election to a district in the House, to a House district, is an election to a federal office run by the state of Georgia or Massachusetts, run by state officials. The election to the Senate seat in Georgia or California or Massachusetts is a state election run by state officials. A presidential election, Eric, is an election of electors.
Yes.
As we know from the electoral college controversies over the years,
Yes.
is a question of how Georgia or Massachusetts or Texas or how they allocate their electors.
But the Constitution does give Congress the power to modify how states do elections.
To modify it. That is true, but these all start as these are state institutions that are regulated by Congress, but still stay state institutions, state elections by state officers. And the idea that the president is a national officer does not change the fact that it's state officials who run these elections. And there's no such thing as a president who gets elected. It is a presidential candidate. So the idea that the problem that the Supreme Court sets up here is that the president is this federal national official, but that jumps forward in the story to after the election. A presidential candidate is someone who's running for electors in the different states. They don't get special status for being a presidential candidate relative to any other candidate. So any other candidate for federal office. So it's just, there's a whole level of just assumptions without any historical or textual support to get there. So that's not just the conservatives. Kagan, Sotomayor, and Jackson all signed on to this federal versus state distinction. And then 5 or 6 of the justices on the right went further to say that none of this can go into effect until Congress is on the self-execution.
So I think people who follow this podcast know I always thought the court should not use Section 3 to disqualify Trump. I had a lot of reasons for that, and I had a lot of ways of getting there. How would you? So I don't disagree with the result in the case. I'm not sure about the reasoning. You're convincing me maybe it was really bad. How would you have decided the case?
So one point, I mean, just to observe here, a lot of people who supported judicial restraint, and lots of people support judicial restraint conveniently. But some people just said, this is just let each state interpret the way it will, make it an issue of federalism. My view was, and this at the Originalism conference I went to, and you usually go. This is the
San Diego.
San Diego one. Yeah. The famous article that people have been talking about by Will Bode and Michael Stokes-Walton, I think was generally a very compelling article. And there was a huge gap in the article, in my view, which bothered me for a while. And it didn't crystallize until they had a Freudian slip in a historical sentence. They were saying that their argument was the Civil War was not a one-off event, that there had been lots of insurrections in American history. And so when they chose to use the word insurrection in the 14th Amendment, Section 3, that it was a broader term than just civil wars, right? This wasn't just a Civil War amendment. They used a more ambiguous and a broadly applicable term that could have had references in the past and references, and
just so the audience knows, Mark Graber, who is one of our leading experts on all of this on the podcast, he agrees with you about that. I mean, I think most historians take that as a given, what you just said. It's just a given.
Yes, but it cuts 2 ways. I mean, so initially, I thought it cut in the direction of saying this was not the reason why it should apply to Trump is they were putting in place an anti-insurrection amendment, not just an 1861 to 1865 Confederate. And I think that's clear. The problem is what counts as an insurrection in the historical context of 1866 to 1868 when this was drafted and ratified. And the sentence, I'm sorry to get in the weeds here, but I think this is an important way to understand how originalism, what in trying to be serious about the history in terms, this is how I think about it. So the sentence they had in this draft was, there had been lots of other insurrections in American history, and which is the reason why they used this term to be broad. And they said, there was the Whiskey Rebellion,
Right.
there was the Shays Rebellion, there was the there's the Denmark Vesey Rebellion, there was Nat Turner's Rebellion. These were all thought of as an insurrections. And I said, well, that's an interesting list, and it's one of these things is not in order. Sesame Street, one of these things is not like the others. One of these things is not like the others. They had listed a bunch of post-ratification insurrections: Whiskey Rebellion, Nat Turner. There was some slave revolts that happened after post-ratification. Gabriel's Rebellion in Virginia, but notably they put the Shays Rebellion after the Whiskey Rebellion. And I thought, whoa, wait a second. The Shays Rebellion of 1786 was the background, one of the root causes of the calling of a constitutional convention, because of the problems of militias and helping states put down debtor revolts. I mean, this is a different conversation for a different podcast, is the class origins of the of the Constitution. But on this point, when the Shays Rebellion had already happened, when they met in Philadelphia, they didn't pass an insurrection clause. They passed and they drafted and ratified in Article 3 a treason clause that was shaped by this experience. And instead of it making it easier to disqualify traitors, they made it harder to punish treason. And this goes back to England from, I think, a statute of 1366 on treason that was very concerned about how treason overlaps with political trials. That accusing, and this is generally a tool of the right wing against the left. So let's be careful what we wish for. It is more common in English and American history for right wing forces to say, we are the nation, and this liberal or progressive has committed treason, and we should execute them. And with a progressive intuition about the misuse of treason, or throwing around the word insurrection, they required two witnesses to the same overt act. I'm basically quoting Article 3. Yeah,
and by the way, Jed, on the two witnesses thing, I have not confirmed this, but I am told that comes from the Torah. The Torah requires.
It does. It does.
Yeah.
Yes. Yes. It comes from a murder conviction. And then the rabbis develop it. So yes, you need two witnesses for capital punishment, and then the rabbis make a series of interpretations to make it almost impossible, because those two witnesses have to have the same perspective on the crime, and they have to testify in the same voice. And the rabbis basically interpret capital punishment out of the Torah by those But
the number two came from that, I think.
So I think that's right. Although the problem is that over in English history, there was a different version of this that had to have one witness to two different treasonous acts. And so there's a bit of a twist there. Anyway, the point is, Eric, that when they experienced the Shays Rebellion, which was a smaller rebellion, more manageable by criminal enforcement and by executions, they said, let's make sure we have treason prosecutions, but let's make it difficult.
Right.
But then when you get to, so Article 3 means be careful about throwing around the word treason and turning insurrections into treason. But when you get the Civil War and something Civil War sized, when you're talking about tens of thousands of people who are implicated. I mean, in addition to the hundreds of thousands who were at least had some military role in the Confederacy. When you get to the enforcement, this is impossible to enforce by criminal law. So let's have a faster way to do this by civil procedure or disqualification. So here's my point. When in the first draft of the Constitution, when the framers of 1787 dealt with the problem of insurrections and treason and rebellions, if it was Shays sized or Whiskey Rebellion sized later, there was a way to deal with it because with a matter of criminal law and criminal sentencing. When they got to the Civil War, they had to do something different and administrative, and so that it had to be Civil War sized. What was January 6th? January 6th was Whiskey Rebellion sized, was Shays Rebellion sized, and it was not Civil War Rebellion sized.
So I want to ask you. So you said at the very that was really interesting stuff, Jed. Thank you. You said at the beginning, though, something that really my entire podcast is usually about, which is you said the question is, what was the original meaning of Section 3 of the 14th Amendment in terms of what is an insurrection, what is not an insurrection? So this is Supreme Myths. I have to mention Richard Posner once every time. So if Posner heard you say that, I know what he would say. And it's exactly the same thing I would say. And I will say I would have said this before I met him, but he also was a big influence on me, obviously. He would say, what are you talking about? That's not the issue. The issue is, and let me finish this thought, what does insurrection mean today? I don't care what it meant in 1868. We need it for today's world. And then I think he would go on to say, if the standard we were talking about, I'm going to make non-legal standards up, but if it was maturity, would it be mature based on 1868 or mature based on 2024? If the standard were something can't be too difficult to break into, is that in 1868 too difficult to break into, or 2020? It seems to me no sane country would look at would look at what's happening in America, would look at January 6th, and leaving aside the ultimate conclusion. I don't want to talk about whether it actually was an insurrection or not. We've been through that. I don't want to talk about that. What I want to talk about is, why in the world would somebody as smart as you advocate for understanding that through 1868 eyes as opposed to 2024 eyes? I don't understand that.
This is the way that the world has flipped since Scalia, and I agree with Scalia, and I have to just point out how the world has flipped.
Sure.
So Scalia, so I'm going to briefly just mention, I just think that text and context are the way to understand law. And we also have other methods like precedent if text and context are unclear, as a matter of truth. But let me shift gears from that point to just embrace something that Scalia said and just say why it's even more persuasive now to me. We also have this legitimacy problem of judging, and the problem of judges just doing whatever they want with no accountability. It is very important to have judicial independence for reasons as a progressive. I cut my teeth on the death penalty. In law school. I was in a clinic for 4 years defending bringing habeas petitions up through the federal and state courts for death penalty defendants, and it was clear that judges just were too scared of the public because state judges face elections, and then on the federal side, it was clear that judges were being appointed because they were known to be pro-death, pro-execution judges, death judges, right? Throughout the 90s, right? Democrats and Republicans. I mean, Clinton made sure to appoint judges who did not have a record of being anti-death penalty. So that point of making sure that judges have a commitment outside their own political or convenient professional advancement and ideology, the history is a check on that. It is not just, because one has this view of rights today, they're just, acting like politicians in robes. That problem is bigger than ever. And so my naive hope, Eric, is that those justices who claim to be originalists are at least circumscribed, that at least there are constraints at them just doing whatever the hell they want because it suits their ideology or their partisan interests, or if in the example of Judge Cannon recently dismissing the Mar-a-Lago cases, I think it is totally fair to ask whether this is partly that these cases are too challenging for her to manage, so she has reached out to some quasi or pseudo-originalist arguments in the background to get rid of the case, or whether she also knows that at this point she has actually quite a good chance of advancement, especially in getting rid of this case, to get elevated to the 11th Circuit and to be on Trump's shortlist to be considered for the Supreme Court. So how do we put any constraint on that? Scalia's point was that history, that the text and context are the historical commitments for what the law meant that put a restraint on judges just making stuff up today.
And we do disagree on this, which is healthy and good. And we're going to get sidetracked now, but I have no choice. I have no choice but to get sidetracked. First of all, I don't think you'll disagree with this. Scalia didn't act on those beliefs. He struck down over 140 laws. Very few of those can be justified by any kind of clear error judicial review. So, but I don't want you to respond to that. My question to you is this: I don't understand where constraint comes from in the following context. The Constitution that gets litigated, not the president has to be 35 and 2 senators from every state, but due process, equal protection, free exercise, freedom of speech, et cetera, unreasonable searches and seizures, cruel and unusual punishments, et cetera, et cetera, et cetera. The text and context of those provisions circa either 1780, 91, or 1868, to me, is a blank slate. It's just a Warsack test. It has no constraining element to it because most originalists agree. And Larry and people have said, originalists have said this on my podcast. Larry Solomon just said it to me in a debate at SMU. If facts, or even in Solomon's words, if opinions about facts change, then judges are not bound by expected applications of the original text. But in our country, that argument's available in every case, because every case involves either 1791 or 1868, and the relevant facts have changed in every case. So I don't understand why you think it has any constraining effect whatsoever.
So there are a couple of. So let me jump to one point that should be constraining, which is instead of it being. There's one framing of judicial review. What should be the standard for a judge to strike down an act of Congress? And this is where we start with deference. Yes. That area is, the judges need to have repugnancy, and that's going to happen very rarely because there's it's remarkable how much of the Constitution is deliberately ambiguous. Deliberately a matter of principles. And so I would even say, what is clear in the Constitution, paradigmatically, it's, you have to be 35 to be president, or, 35 or older, like things like that. Or I would say tenure during good behavior, because it had clarity. And then we have things like equal protection and due process, which we know historically, the reason why they put those provisions in as ambiguous as they did is because they couldn't work out the applications. And they wanted to invite construction. So I'm an originalist who says, we have 3 different boxes: the box of completely clear, the box of clear enough, and then the box of ambiguous and probably deliberately ambiguous to invite construction. The best. So that's on the one hand, right? And then on the about how clear it doesn't have to be to strike down an act of a state or of Congress. But then there's this flip side thing, which is inventing stuff. of like presidential immunity, and it's interesting how much that presidential immunity decision is just about the most anti-originalist decision one can read from the Rehnquist to the Roberts Court,
except for Bruin, which is more. Go ahead.
I think this case is worse.
It's hard to believe.
It's a mess, but it at least pretends to have. It at least pretends to use originalist methods. The thing that's stunning about the presidential immunity decision is it generally abandons originalist methods while still pretending like it has this commitment to the originalist invention of separation of powers. So this is different from the court intervening against another branch, right? This is departmental nonsense. This is the Supreme Court inventing out of whole cloth a concept of immunity that the framers rejected, and all of the evidence indicates from English history that's relevant to executive power that's beyond the king, and also to the American founding, that this immunity was rejected. And so the only originalist basis for the argument is this is separation of powers myth on steroids. Right.
I want to talk about that separation of powers myth on steroids, because we're running a little bit out of time here, and sure. I want to give you a chance to discuss what you've written about it, what I find so fascinating. One of the many fascinating things I find about your work. So it's always been my view And although I know a lot about separation of powers, I don't view that as my wheelhouse. I have other wheelhouses like standing and stuff like that. But I teach it, so I know enough about it. It's always been my view that in most separation of powers cases, we should let Congress and the president work it out. Just figure it out. The judges
Right.
should just go away. Now, if someone's private rights are really being injured, then maybe we have to adjust for that. I'm not sure. I don't want to get into that so much.
Yep.
I think your view is not that far away from my view, is it?
It is because of the historical research I've been doing over the past year. I've now
Yes.
arrived.
Okay,
So
defend that view. Great, defend that view.
let me say what the old view was, and it relates
Yeah.
to another major case about executive
Yeah.
power. Do you want to touch on
Yeah,
Chevron?
yeah, sure. Yes,
And
sure.
Rupert
Yes.
Bright? Yeah,
Yeah.
I used to, I used to be a vocal critic of Chevron. I mean, I did not support Gorsuch's nomination in the end, but I thought Gorsuch was one of the most vocal critics of Chevron deference. I think most of your listeners probably at this point know what Chevron deference is. But
Yes.
the idea that courts should defer to a reasonable interpretation of a statute. And my view, and I teach administrative law as well, Eric, is that there was something a little bit weird that the courts are supposed to give hard look to policy, but defer to statutory interpretation when statutory interpretation is, quote, a judge's job. And I used to believe this line that Roberts has used more than any other line in his time on the Supreme Court, that quoting Marbury versus Madison from 1803 and saying in the basis for judicial review, the line is, it is emphatically the duty and province of the judicial department to say what the law is.
And let me just say, that's the line the court always uses. The court used it in Cooper versus Aaron. The court
That's
used
right.
it in U.S. versus Nixon, Bush versus Gore, in all the big cases.
And the major questions doctrine that basically made Chevron a dead letter by the time they struck it down. I mean,
Yeah.
in any case you were worried about, any case that was significant enough for the court to grant cert on it,
Yes.
it would be a major question. And as long as it's a major question, Roberts would say, well, it's emphatically the province duty of me, I just happen to love this line that tells everyone that it is my duty, province, and power and God-given right to tell everyone what the law is.
Yeah.
Roberts and four of my friends, generally my male friends, because
Yes.
Amy Coney Barrett has put herself Amy Coney Barrett's separating herself from the group.
No, she's not, but that's different. That's different podcast.
A little bit.
Different
But
podcast.
anyway,
Okay.
the point is, it turns out that this was always hokum because
Right.
of that line judicial department. This is another reason, Eric, why it's important to get history right in originalism. It sounds today like it is the judiciary the judicial department, departmentalism is a theory of judicial review that is very narrow. It doesn't mean that the Supreme Court can erase statutes. It just means we within the courts have to be careful in how we apply things with a certain high standard of repugnancy. Whereas the executive branch has its own department. The executive is its own department.
And in fact, in Marbury itself, Marshall phrases the question as, what's a judge to do when he has a statute that's inconsistent with the Constitution? Which should a judge apply? But it's all from the judge's perspective. It's what's our duty in this department. It doesn't speak to their duty. Sorry.
That's right. So what is Chevron and Chevron deference is a case about departmentalism. When something is in the domain of executive agencies and executive administrative adjudication, it is the executive department. And it turns out, Eric, without going into all the detail, that from English and American history, it was emphatically the province and duty of the executive department to also say what the law is within its own department. And all Chevron was, as a matter of, jurisprudence and matter of constitutional law, was, in retrospect, they didn't make these arguments, but it is consistent with the departmentalism from the beginning. But here's another twist on the story, which is
I'm sorry, Jed. One last thing. If folks who are skeptical of this departmentalism theories, they shouldn't be. Jefferson adopted it. Lincoln adopted it.
Right.
I think Roosevelt adopted it. I mean, not surprisingly, but still.
And then it's been American law from the beginning.
Yeah.
The first Congress created agencies with massive discretion. I mean, this is Nick Perillo's work at Yale about the first property taxation, the latitude. This is also about massive delegation of rulemaking power from the beginning, because obviously
Yes.
they right, like the federal government only had about 150 employees, right?
I've said many times on this podcast that I believe the first Congress said to George Washington, "Here's $1 million. Spend it, don't spend it, figure it out."
I here's $1 million for building lighthouses. Go
Yeah,
build it. How about this? We're gonna someone should pick a place to put the capital. We haven't figured it out. Here is 200 miles stretch between Maryland and Virginia. Go pick a spot. I mean,
yeah.
that sounds like what Roberts would say is lawmaking. It's not an
Or a major
intelligent.
question. Certainly
It's
a
a
major
major,
question.
but it's the delegation without an intelligible principle. Go pick a spot for the District of Columbia, somewhere between Maryland and Virginia, along this 300-mile stretch of river with nothing in that
Yeah.
statute.
Julian Morgenstern and Nick Bagley wrote a 100-page semi-book that
That's
is
right.
just replete of strong delegations at the beginning with no limiting principles. There is no originalist argument supporting the Roberts Court destruction of the administrative state.
That's right. That's right. Now, I do quibble with some of it, both historically and methodologically, about where the line is. And I've actually done some more research on this that complicates. But I don't want to get into all of that. I just want to
Yeah,
say the point about the separation of powers is that judges were executive officers up until 1787. There is no dictionary or treatise, not even the one cited, like, the people pretend like Montesquieu had this worked out. First of all, I don't think Montesquieu wrote the Constitution. And correct me if I'm wrong. I don't think Montesquieu was in Philadelphia. I think Montesquieu was dead at this point, right? And I don't think Montesquieu ratified. So let's just say Montesquieu was their Bible. Like Montesquieu didn't actually rejected this idea that judges should have any lawmaking power because they had no
right,
estate. They
right.
didn't have a basis of legitimacy. So at best, he would say what he actually said is judges are adjudicators with no legal authority to make law, find law, and interpret law at this scale. So even their prophet and really what I mean by prophet of separation of powers is someone who expected in the future for someone to work this out. And maybe I also
So,
mean prophet by
so let me.
the corporate aspect of separation of powers, profit,
Right, right.
Profit. But go ahead.
Yes.
Yeah.
We're running out of time, and I could
Yeah.
talk to
Yeah.
you for
Yeah. Go
about
ahead.
3 to 4 weeks. But let's take a real life example here, okay?
Yeah.
So it's 1952 or three, I forget, and we're fighting a war in Korea. We're not calling it a war, but it's definitely a war. Men and
Yeah.
women are dying, and there's going to be a strike. And Truman wants to seize the steel mills, and the argument is, and his lawyers say men and women will die in Korea if we don't do this. And he says, I have the power as commander in chief. I have the power to execute the laws that Congress passed, funding the police action in Korea, and so on and so on. I don't care about your views on who was right or wrong.
Right.
My
Right.
question to you is, because there was private property at issue in that case, right? The steel mills are saying this is our private property that you're taking illegally. Do we ask for a little more judicial involvement when such a high level of private right is at stake, or do we go with the Siegel Sugarman general rule, which is judges should stay out of this?
I mean, so this is where things get difficult, right? This is where you have to have the commitments of, this is a constitutionalism that I'm talking about, of where the text and context are have to be clear. I teach Youngstown. I teach this case. So it's
Yeah,
hard for me to separate it entirely. But my big picture perspective is that I am a rule of law. My commitment to constitutionalism is that the rule of law needs to put constraints on powerful political actors, and no one is as dangerous as the president. And it's not just me interpreting that. I mean, it turns out this is another myth of the Roberts Court, which is, Jody Short and I have called this the myth of presidential superiority, that the president is the most democratic, the most, the most democratically elected accountable official for the entire national government. And it's not just, I think this is true as a matter of the framing of the Constitution. They were particularly worried about tyranny, and they were worried about Congress. They were worried about the president. They had worries about centralized power. So this is where I think, Eric, that the text and context of the Constitution are clear enough. But the key to that case was what Congress said. The key to that
Right.
case was what Congress said. And so, in some ways, the way to understand the check on presidential power in that case was it was in a fight between Congress and the president. You can't just give up on law and just say work it out, because that's how you get civil wars. And and I have to say, we're recording this in July of 2024,
Yeah.
where the prospect of violence. I mean, the courts are also supposed to resolve conflicts with nonviolence, and I am concerned that both the courts staying out of things lead to the president and Congress working it out. I don't, I think we've seen historically that has led to violence, but I'm also worried that the Supreme Court is contributing to this environment of
Yeah.
lawlessness and the
Okay.
presidential immunity decision. So that's my best answer at this, on one
Fair enough.
leg.
So we have like 3 or 4 minutes left. My last question is this. I always thought that the immunity question was being made way too complicated by everybody.
Yeah.
Now, I have a tendency to do that. I'm fairly criticized for that from time to time. So, but to me, if it's an official act, by definition, it's not a criminal act. And if it's not an official act, it might be a criminal act, depending if there's a law making it criminal.
Yeah. Right.
And that's all we need.
That's right.
What,
That's the
so
DC Circuit.
yeah. So this whole idea that we can't use motive evidence to separate those two things out, we can't use evidence of official acts to decide what's unofficial. All of that, Jed, felt like it was handwritten to help Trump to me. My question to you is this. You're the judge. Judge Shugerman gets to decide what is the law, and this is the last thing I'll ask you, what is the law of presidential immunity? What should it be in this country? What should the law be?
I thought the DC Circuit got it. I thought you described the DC Circuit, and I thought the DC Circuit was right on this. I would say that I thought the Roberts Court was intervening. No way that they would write such a crazy opinion. They were just intervening to grant cert. Jack Smith asked them to grant cert early to bypass
Right.
the DC Circuit so they could get a trial started early. They said, no, thanks. Let's let the DC Circuit write the opinion. The DC Circuit wrote a very good opinion. Was it perfect? No. But
And a
so-
Trump appointee too joined it.
a Trump appointee joined it, and I'm glad they took the time they did, because it was thorough and clear enough. And yet the Roberts Court then grants cert. So now we know the reason why they granted cert actually had some substance to it, because they wanted to write a lunatic, far right wing opinion. But they did everything they could to delay it. Now, I'm going to go further. I think they did mean to benefit Trump. I think they were also affected by the Manhattan DA's prosecution. I think they were watching a lawless process. Of all the horrible things that have happened in the last 8 years, the Manhattan DA is far from anywhere on the top 100 list of threats to the rule of law. Nevertheless, it was a lawless. I called it a historical mistake and a legal embarrassment, precisely because it validated the toxic grievance politics of MAGA, that the world is out to get us. Well, in this case, the Manhattan DA was out to get them.
We agree on that.
But the point is that I think it was more than just to help Trump. I agree with you that they were consciously trying to help Trump, but I also think they are conscious. They have a cult of presidentialism, that they have a dangerously authoritarian friendly view of presidential power. They are making it is anti-originalist to have this view of the presidency, deeply anti-originalist, and it is maybe more dangerous long term to America that they have baked into a presidential, unchecked presidential power in many different ways, that other presidents can misuse, not just Trump. And so I think that's where the Supreme Court's legitimacy has collapsed in this past term.
Well, that was a spectacular answer and a great way to end this podcast. Jed, thank you so much for being here. You are one of my go-to people. I have like 3 of them for presidential power issues. Last time you were here, you debated Mike Ramsey. That was one of the most watched episodes of this podcast ever, to be honest. So thank you very much for being here, and I hope we talk again.
Thank you, Eric. Great questions. I really thank you for doing this podcast, which helps, I know, many law students use this as help to give them guidance in a time where it's very hard to understand what this project of law is, and when the general public needs your questions and this conversation to give us some hope. I hope about.
I don't know. I don't know. I will say this: the next time you're on, we are going to debate the Boston Celtics, but that's the next time.
That sounds
Jed,
great.
thank you so much for being here.
Thanks, Eric. I appreciate it.